So after the Supreme Court told the Second Circuit to finally do their jobs, the Second Circuit has now expedited 6 hearings which challenge the state of New York's defiance of the New York State Rifle and Pistol Association v. Bruin decision. So let's talk about this. But real quick before we jump in this video, I want to mention that the Gundy's voting is currently open. Last year we won the Top 2A Voices, our channel won, and it would be awesome for us to win 2 years in a row. So if you're interested, if you would like to support the channel, if you would like to vote for our channel to win, you can vote using the links down below. And regardless, thank you guys so much for all of your support. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice, but instead to help you understand what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video we will be discussing how 6 cases have now been expedited by the Second Circuit because of the recent warning that the Supreme Court issued to the Second Circuit. This is a generally positive thing because the Second Circuit is no longer able to drag their feet on all these cases and essentially have them in a continued holding pattern. Instead, they will need to resolve these cases as soon as possible. These 6 cases challenged the state of New York's new Concealed Carry Improvement Act, also known as the CCIA, which ultimately creates a hyper-restrictive concealed carry law within the state of New York. And the state of New York passed their law just 9 days after the Supreme Court issued a landmark decision in New York State Rifle and Pistol Association v. Bruin. And that decision ultimately struck down the state of New York's previous concealed carry laws. In Bruin, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of the Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. But another really important thing that the Supreme Court did in that decision was that they stated the state of New York and other states could not simply make everywhere within an entire state a sensitive location. Justice Thomas, writing for the majority, actually stated, "The respondents' attempt to characterize New York's proper cause requirement as a sensitive place law lacks merit because there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place, simply because it is crowded and protected generally by the New York City Police Department." He went on to state that expanding the category of sensitive places simply to all places of public congregation that are not isolated from law enforcement defines the category of sensitive places far too broadly. Respondents' argument would in effect exempt cities from the Second Amendment and would eviscerate the general right to public carry arms for self-defense. However, despite that decision, the state of New York rushed through the Concealed Carry Improvement Act, also known as the CCIA, which made the permit scheme in the state of New York even worse than the one that existed prior to Bruin. And the state of New York did this in direct defiance of the Supreme Court's decision in Bruin. Because of how this law directly violated the Second Amendment and what the Supreme Court said in Bruin, a variety of lawsuits were filed against the state of New York. In a GOA case, Judge Sotheby, the district court judge there, heard a request for a preliminary injunction and ultimately granted the request for a preliminary injunction against various aspects of the CCIA. In that decision, he struck down portions of the law like the good moral character standard and also the catch-all sensitive location restrictions. After that, the state of New York decided to appeal that preliminary injunction being granted, and they appealed that up to the Second Circuit and requested for the Second Circuit to place a stay on that judgment. The Second Circuit, on review, ultimately granted the stay, which prevents the Judge Sotheby preliminary injunction from having any current impact. Now, instead of waiting around for the Second Circuit to ultimately do their job, GOA filed an emergency application up to the Supreme Court. The emergency application asked the Supreme Court to vacate the Second Circuit's grant of the stay. And in response to that emergency application, the Supreme Court denied the request, but Justice Alito and Justice Thomas issued a firm warning to the Second Circuit. And here is that warning that they issued to the lower court. They stated, "The New York law at issue in this application presents novel and serious questions under both the First and Second Amendments. The district court found, in a thorough opinion, that the applicants were likely to succeed on a number of their claims, and it issued a preliminary injunction as to 12 portions of the challenged law. With one exception, the Second Circuit issued a stay of the injunction in full, and in doing so, did not provide any explanation for its ruling. In parallel cases presenting related issues, the Second Circuit has likewise issued unreasoned summary stay orders, but in those cases, it has ordered expedited briefing. I understand the court's denial today to reflect respect for the Second Circuit's procedures in managing its own docket, rather than expressing any view on the merits of the case. Applicants should not be deterred by today's order from again seeking relief if the Second Circuit does not, within a reasonable time, provide an explanation for its stay or expedite consideration of the appeal. So although the Supreme Court denied the emergency application, the opinion did state that the Second Circuit cannot simply drag their feet on this issue for very long. Instead, the Supreme Court is giving them one last chance to actually do their jobs. They, the Second Circuit, could either issue an opinion on why they granted the stay, or they must expedite the hearings on these cases which are challenging the CCIA. The warning of the Supreme Court also indicated that if the Second Circuit does not respond appropriately, then the plaintiffs can re-seek an emergency application from the Supreme Court, and all indications are from the language in that opinion that at that point, the Supreme Court would in fact grant review. And it appears that the Second Circuit has taken that warning seriously. We received an order from the Second Circuit that they are going to expedite review of 6 different cases which challenge the constitutionality of the CCIA. Those 6 cases are the Antioch case, the Hardaway case, the Christian case, the Superintendent of New York State Police case, the Gazzola case, and also after those 5, they added into the fold the Spencer case as well. These cases challenge various aspects of the CCIA. The Antioch case challenges the permitting scheme generally. It includes the sensitive location restrictions, the good moral character standards, and other things as well, the whole application process. The Spencer, Christian, and Hardaway cases, I believe, challenged the place of worship restrictions and the carry ban at places of worship. And then the Gazzola case is a challenge to how the CCIA is in fact impacting gun stores and gun dealers. The order that the Second Circuit issued simply lists all of those 5 cases and says that it is hereby ordered that the above referenced expedited appeals will be heard in tandem on March 20th, 2023. So on March 20th, the Second Circuit will hear all these cases in tandem and determine whether or not the state of New York and their new concealed carry law is in fact consistent with the Second Amendment and also the Supreme Court's decision in Bruin. This law has already been found unconstitutional 5 times in the lower courts, and now it's time for the Second Circuit to do the right thing and also to strike down this overreach by the state of New York. So this is something we will definitely be keeping our eyes on closely to see what the Second Circuit ultimately decides to do, if they are going to faithfully apply Bruin and find that this is indeed unconstitutional. If the Second Circuit does have a video available, maybe we can do a live stream of it, of the hearings, if you guys are interested in that. If you're interested in that, you can leave a comment down below, and maybe if there's enough of you that wanted something like that, we can do a live stream. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.